For fans of The Big Bang Theory, few things evoke a sense of nerdy nostalgia like the show's endearing lullaby, Soft Kitty. Sung lovingly by Sheldon Cooper when he's sick, or feeling particularly emotionally needy, the tune became an inside joke among fans and a symbol of Sheldon's peculiar brand of comfort. But behind the scenes, the sweet and simple song was at the center of a rather unsoft legal battle that drew the show into unexpected controversy. It's a curious thing when a few innocent lines of a lullaby can spark a lawsuit. But in Hollywood, where billions of dollars orbit every hit franchise like electrons around a nucleus, even the softest kitties can scratch. The song that launched 1,000 memes. Soft kitty, warm kitty, little ball of fur, happy kitty, sleepy kitty, purr, purr, purr. The lyrics are simple, almost childlike. For Sheldon, they're practically sacred. Over the show's 12-season run, the song appeared in several episodes, sometimes sung by Penny, sometimes by Sheldon himself, and always in that slow, oddly soothing cadence that cemented its pop culture status. But what most viewers didn't know was that these lyrics weren't penned by the show's writers. They were adapted from a poem written long before Sheldon's theoretical physics career or Penny's acting aspirations had ever graced a TV screen. Enter the daughters of Edith Newlin. The lullaby's lyrics were originally part of a poem written by Edith Newlin, a New Hampshire schoolteacher and poet. In 1937, her poem titled Soft Kitty was published in a book called Songs for the Nursery School. The book was created by Willis Music Company, which compiled songs and poems for use in classrooms. Fast forward nearly 70 years. In 2007, The Big Bang Theory debuted. Soon after, Sheldon was serenading viewers with Newlin's decades-old words. Her daughters, Ellen Chase and Margaret Perry, eventually noticed the uncanny resemblance. They weren't just seeing their mother's poem quoted, they were seeing it become part of merchandise, YouTube compilations, and Hallmark cards. And they weren't seeing a dime. The lawsuit. In 2015, Chase and Perry filed a lawsuit against Warner Bros., CBS, and other associated production companies. Their claim was that The Big Bang Theory had used their mother's work without permission and profited off it, particularly through merchandise and promotion. They argued that Warner Bros. Had failed to acquire proper rights to the lyrics. According to the daughters, the poem may have been printed in a music book, but it was never meant to be commercialized in the way it had been by the show. The defendants, however, had a different story. According to Warner Bros., they had secured the rights from Willis Music Company, which had published the poem. They claimed this gave them all the necessary permissions to use the lyrics in the show. The big question, then, was, did Willis Music actually have the rights to license the poem in the first place? A courtroom catfight. The legal fight hinged on a very specific point, whether the poem had been properly copyrighted and whether that copyright had been transferred to Willis Music. If not, then Edith Newlin's daughters might indeed have had a case. But the court wasn't convinced. In 2017, a U.S. District Court judge dismissed the case. The ruling concluded that the plaintiffs hadn't demonstrated sufficient ownership of the copyright to pursue a claim. Essentially, they couldn't prove they held the rights to sue. It was a quiet end to a loud story, one that might not have made headlines if not for the song's enormous popularity. The show went on, the song stayed in pop culture rotation, and Soft Kitty became another quirky footnote in the annals of TV history. The bigger picture. While the Soft Kitty lawsuit might seem trivial at first glance, it touches on a much deeper issue in the entertainment industry: ownership of creative content. Who really owns a poem once it's been published in a book? If it's used for educational purposes, can it then be used for commercial ones? What happens when that work is rediscovered decades later and used by a multi-million-dollar franchise? These are questions that legal scholars and artists alike continue to grapple with. In a way, Soft Kitty became a test case for how the entertainment world handles old content in new formats. The case also highlights the emotional side of intellectual property. For Newlin's daughters, it wasn't just about the money, it was about recognition. Seeing their mother's words become famous without attribution felt like an injustice, regardless of the legal specifics. A song lives on. Despite the lawsuit, the charm of Soft Kitty hasn't faded. It lives on in reruns, fan art, and the collective memory of a generation of viewers. It's become part of the show's DNA, right up there with Sheldon's Bazinga and Howard's cringe-worthy pickup lines. In fact, the song became so iconic that it inspired a children's book, Soft Kitty, a touch and feel book, officially licensed and marketed to the youngest fans of the show. Ironically, the same song that caused a courtroom clash was now being repurposed for toddlers, completing a strange cultural loop from nursery school to primetime TV and back again. Final thoughts. The story of Soft Kitty is a reminder that even the gentlest lullabies can have a complicated backstory. It's also a testament to the power of simple art, a short poem by a schoolteacher turned into a symbol of comfort for millions. Whether you're Team Warner Bros. Or Team Newlyn, there's no denying that Soft Kitty became more than a song. It became a phenomenon, and like any good piece of pop culture, it sparked conversation, controversy, and just a touch of chaos. So next time you hum those 6 little lines, remember, even a sleepy kitty can wake the legal lions. Would you like this turned into a blog post or stylized article layout too?